Welcome to the maiden series of Harlem Legal Spotlight. My name is Mary G. Here with me is my colleague, Similoluwa Adekanye. She is a member of the ADR practice group at Harlem Solicitors. Welcome, Similoluwa.
Thank you very much. Thanks for having me.
All right, so today we'll be speaking on the role of ADR in commercial disputes. So, Similoluwa, can you give us a brief overview on ADR?
ADR is an acronym for Alternative Dispute Resolution, which simply is the process whereby disputes are resolved by alternative means. ADR have several mechanisms. We have arbitration, negotiation, conciliation, early neutral evaluation, expert determination, and several others. ADR is regulated by an act known as the Arbitration and Mediation Act of 2023. This act reviewed the previous act, which is the Arbitration and Conciliation Act of 2004. There are other laws or statutes that also recognize ADR. We have the 1999 Constitution, which is the Constitution of the Federal Republic of Nigeria as amended. By virtue of Section 19, Paragraph D, the Constitution provides for the use of alternative dispute resolution in resolving disputes before matters are taken to court. Yes, it is also recognized under Rule 15, Sub-Rule 3, Paragraph D of the Rules of Professional Conduct for Legal Practitioners of 2007. Pardon me. Yes. So these statutes and laws make provisions generally to find alternative means in resolving disputes instead of going to court, which is the litigation procedure. Yes.
Oh, okay. I mean, that is wonderful. So tell me, are there any changes introduced in the Arbitration and Mediation Act of 2023?
Yes, there are. The Arbitration and Mediation Act, AMA, of 2023 introduces several changes to the legal framework for ADR in Nigeria. Some of the key changes are: number one, it expands the scope of mediation. It also introduces the provision for emergency arbitration in Nigeria. Then it also enhances the enforceability of arbitral awards and also promotes the use of technology in resolving disputes in Nigeria.
Okay, you made mention of emergency arbitration. So, I mean, just tell me, what does emergency arbitration mean in commercial disputes?
By virtue of Section 16 of the Arbitration and Mediation Act of 2023, emergency arbitration refers to the process where parties can seek urgent interim relief from an arbitrator before full arbitration proceeding begin. It allows parties to address time-sensitive issues such as such as preserving their assets rather, or
Okay.
preventing irreparable harm while waiting for the main arbitration to take place. This ensures that the rights and interests of the parties are protected during the early stage of dispute resolution, and it is a very useful tool in addressing urgent matters in arbitration cases.
Oh, okay. I mean, that's enlightening. So, tell me, can emergency arbitration be used in international commercial disputes?
Yes, it can. Um, as I've said, emergency arbitration can be is used where parties seek urgent interim reliefs in resolving their dispute.
Okay.
So likewise, emergency arbitration can be used in international disputes because it provides a mechanism for parties to seek urgent interim reliefs regardless of any jurisdiction um, the dispute arises. It also allows parties to address time-sensitive issues and obtain temporal relief before the main arbitration proceeding begins.
So, how does emergency arbitration differ from regular arbitration?
Emergency arbitration differ in terms of purpose and timing. Regular arbitration is a main process where parties prevent their cases and a decision is reached by an arbitrator or a panel of arbitrators. Emergency arbitration is fast tracked, that is like interlocutory application process
Okay.
for litigation.
Oh, okay.
So emergency arbitration is fast paced, and it involves seeking urgent interim relief from an arbitrator, just as we have, as I've said, in interlocutory application in civil or criminal cases.
Okay. That's wonderful. Okay, so tell me, what kind of matters can be brought before ADR, and are there any areas of law that cannot use ADR mechanism in resolving disputes?
Yes, there are.
Okay.
Um, Corporate and commercial matters, um, civil matters
Mm-hmm.
can all be resolved through ADR.
Okay.
Yes, aside from this, there are several others. However, issues as regards election petition,
Mm.
criminal matters, interpretation of law, or matters that has to do with the fundamental right enforcement, to mention a few, cannot be resolved by ADR.
Okay. So how different is ADR from the regular court?
ADR process is very different from the regular court,
Mhm.
which is the litigation process. The result, however, is quite similar in that arbitration, which is one of the mechanism of ADR, results in a binding decision and can be enforced by the court. That is the final decision
Okay.
of the arbitration now can be enforced. It's called an award. And if you look at the regular court system, which is the litigation now, the final decision is known as judgment. So this can be enforced. However, um, the arbitral award, sorry, can be enforced by another jurisdiction so long as they are part of the New York Convention. Same way, decision in another jurisdiction can be enforced in Nigeria, having met the requirement. Aside this, ADR is very different from litigation in that the former, that's the ADR,
Mm-hmm.
alternative dispute resolution,
Yeah.
leads to a more collaborative and less adversarial means in resolving disputes, unlike litigation that results in a win-lose situation. So arbitration leads to a win-win. Yeah,
Okay.
win-win situation. That is, once parties bring their matters to be resolved through ADR, there is a guarantee that their matters will be resolved, and both parties will leave amicably. Like their issues will be resolved amicably, which leads to a win-win situation. Unlike the litigation process that is always adversarial, difficult,
Mm-hmm.
stressful, and time consuming. Yes.
Okay, that's beautiful. Um, so tell me, how are the ADR mechanisms distinctive from each other?
The ADR mechanisms that we have in Nigeria currently, like that we make use of, is arbitration and mainly mediation. So, firstly, all these mechanisms
Mm-hmm.
are consensual,
Okay.
yes, but arbitration is different because arbitration leads to a binding decision that can be enforced by court by virtue of section 57 sub 1 and subsection 2 of the Arbitration and Mediation Act 2023.
Okay.
So yes, so mediation on the other hand and conciliation are subject to contract. For mediation, one has to enter into a settlement agreement, and without this, the decision cannot be final. So, looking at all this mechanism, the only difference, the only similarity, so to say, amongst them is that they are consensual.
Okay.
Yes, but arbitration results in a binding decision,
Oh,
unlike
okay.
mediation and conciliation.
Oh, all right. So Similoluwa, it's been insightful. So tell me, What is the implication of inserting an arbitration clause in a commercial agreement?
There is need for parties to think carefully about the clause to insert into their contract. Aside from
Okay.
that, lawyers need to be more intentional about these clauses. Um, Arbitration clause, inserting arbitration clause in a contractual or commercial agreement helps prevent the long, expensive, and rigorous process of going through litigation to resolve disputes. By virtue of Section 5 of the Arbitration and Mediation Act of 2023, um, it states that where an arbitration clause is inserted in a contractual or commercial agreement executed by contracting parties, both parties must abide by the arbitration clause before going to court. So what this implies is before we can take our matter to court or through litigation, we must first consider using the ADR mechanism to resolve the dispute, so long as an arbitration clause is inserted in our contractual agreement. So this means that once there is an arbitration clause in an agreement, the parties must go to arbitration first. So when one of the parties proceed to court contrary to the arbitration clause, um, the other party may apply for a stay of proceeding, and the court, upon fulfillment of all the requirements or relevant conditions now, will stay the action.
Oh,
So,
okay.
however, such party, that is a party seeking for the stay of proceeding, must ensure that he or she hasn't taken part in the proceeding.
No, okay. I mean that is great. I think this is one most important question I've been wanting to ask you. So, which would you rather go for, ADR or litigation, bearing in mind the cost implication?
Um, if I can get my issues resolved amicably within a shorter period of time for a cost, why not? I would I would consider taking my issues or grievances to ADR to be resolved instead of going through the rigorous process of the court system, which is very stressful, time consuming and adversarial. Um, I would consider ADR in resolving disputes.
Similoluwa, thank you so much for gracing this interview. It has been insightful, it has been educative. I'm very sure we all learned one or two things about ADR and its roles in commercial disputes.
Thanks for having me. Thank you so much.
So we've come to the end of today's episode of Alem Legal Spotlight. My name still remains Mary G. Esene. Thank you.